Good morning, Mr. Sims, right? Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Welcome back to another explosive courtroom breakdown. Today, we're diving deep into Judge Fleer's Harris County courtroom, where the drama is real and the stakes couldn't be higher. We've got a father who allegedly punched his partner right inside a NICU ward. Yes, inches away from their newborn baby. A stalker who made over 109 calls in a single day after being told to leave someone alone. A high-speed police chase topping 100 miles per hour with a loaded handgun hidden in the glove box. And a woman who allegedly stole a phone from a nail salon, then had her 12-year-old daughter hide the evidence in the trunk. These cases are absolutely wild. This judge is not playing games, and the consequences are life-altering. Buckle up, because this session is about to get intense.
Okay.
On March 16, 2025, at 929 Gustin Road in Harris County, Texas, the Memorial Herman Tower NICU, the officer made contact with the complainant. The complainant stated the defendant, the father of the child, was staying overnight at the NICU with their child. The complainant stated that when she arrived, she observed their child to be in the bed with a blanket fully covering the child's face. The complainant stated that she pointed this out to the defendant, which upset him. The complainant stated that she then asked to remove the blanket from their baby's face, which the defendant refused. The complainant stated that she then moved towards the baby carriage to remove the blanket, to which the defendant stepped in her way and pushed her back. The complainant stated that she reacted by pushing him back. The complainant stated that the defendant then cocked back his arm and punched her in the face with a closed fist, striking her on her left forehead near her temple. The complainant stated that she felt pain from the punch. The complainant stated that the hospital staff overheard the commotion and escorted the defendant off the premises. The officers observed a small mark on the complainant's forehead where she stated she was struck.
Hold up. Let's break down what just happened here. This alleged assault took place in a NICU, the neonatal intensive care unit, where premature and critically ill babies receive life-saving care. According to the complaint, the mother arrived and found a blanket fully covering her baby's face, a serious safety concern. When she tried to address it, the defendant allegedly blocked her, pushed her, and then delivered a closed fist punch to her temple. Hospital staff had to escort him off the premises. The officers noted a visible mark where she said she was struck. Now, the judge is about to make a probable cause determination. Remember, probable cause doesn't mean guilt. It means there's enough evidence to believe a crime may have occurred and the case should move forward. The bar isn't proof beyond reasonable doubt yet, but it's still a serious signal. Watch closely how the judge handles this.
Okay, Mr. Sims, I'm going to find that there's sufficient probable cause to go forward with the case. It appears a protective order has been issued. I will get to know it. If you do something to violate the protective order, the state can and will probably file a violation of the protective order against you. It's one of the worst cases you can pick up. Do you understand? Do we know whether she wants to have contact with him or not?
We have not been able to make contact.
Okay. I don't know if she wants to have contact with you, so at this point in time, I'm going to order you not to have any contact with her and not to be in possession of weapons. If you violate this, I will revoke your bond, put you in jail. I will do everything in my power to protect every single person in this county. Do you understand, Mr. Sims?
Yes, John.
Now, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Ms. Wright, and she will tell you if and when you have to come back to court. If she tells me that you've gone AWOL, she can't get a hold of you, you're ducking and dodging phone calls, I will issue a warrant for that. Don't pick up any new cases. It will not go well if you do. For now, we'll have you sign a reset with Victoria. I'll have you take a seat in the jury box while we generate your bond conditions. We'll have you sign it, and then you'll be free to go.
Thank you, Your Honor.
Please. Joshua Rosas.
Yes, sir.
Mr. Rosas, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 20th, officers were dispatched to a burglary of a residence in progress located at 12719 Greenshire, Houston, Harris County, Texas. The complainant stated that on Friday she ended her dating relationship with the defendant. The defendant continued to call and text her throughout the day. The complainant stated that the defendant showed up unannounced at the listed location and attempted to enter the residence through the bathroom window. The complainant explained that the defendant opened the bathroom window and threw a stick inside the home. Officers observed multiple calls and text messages on the complainant's phone. On March 16th, 2025, there were 3 missed calls. On March 17th, 2025, 1 missed call. And on March 19th, 2025, an estimated 109 or more missed calls. The officers noted text messages from the complainant on March 16, 2025 with statements saying, "Leave me alone and please don't bother me anymore." The officers observed approximately 69 text messages from the defendant to the complainant on March 19, 2025. The complainant stated she is in fear for her safety.
109 missed calls in a single day. Let that number sink in for a moment. After the complainant clearly told him to leave her alone and ended the relationship, this defendant allegedly bombarded her with over 100 calls, nearly 70 text messages, and then physically showed up at her home and tried to enter through the bathroom window, even throwing a stick inside the house. This is textbook stalking and harassment behavior, and the escalation from digital harassment to attempted physical intrusion is deeply alarming. The complainant explicitly stated she fears for her safety, and honestly, who wouldn't? The pattern here is clear. When someone says, "Leave me alone," and you respond with 100+ calls and an attempted break-in, that's not love, that's obsession and control. Watch how Judge Fleer handles this one, because he's known for coming down hard on cases that endanger victims.
Mr. Rosas, I'm going to find that there's sufficient probable cause to go forward with the case, and I'm ordering you now as a condition of your bond not to attempt any contact with this person and not to be in possession of weapons. I don't want you to go within 1,000 feet of where this person lives or where the person works. If I find that you do, I will put you in jail, and I'm going to tell you now, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, sir.
I will protect every person in my county. I don't care what color, who you are. Do you understand? Do you have the red pen in this case? When is the last time you've talked to her? Is it continuing?
So,
Judge, we haven't spoken to her yet. I did post a phone call. I haven't heard back from her. That being said, our victim assistance coordinator is in contact with her.
I'd
So
like
we
to
can
know if it's still continuing, because if it is, I'm going to put a monitor on his ankle. If it is stopped, then I'm not going to. So perhaps maybe later on, you guys, if you don't mind reaching out just to make sure that it's stopped, and we'll go from there. Do you have the ability to hire a lawyer, Mr. Rosas?
No, when I put a lawyer.
Sorry?
Say that again?
Do you have the ability to hire a lawyer?
Can I get an appointed one?
You have to qualify. We don't give them like it's candy on Halloween. You have to actually qualify. So what I can do is I can have Deputy Miranda give you an application. I need to know everything about you. How much money you make a month, how much money you have in the bank, what kind of car you drive. Fill it out, put everything on there, and then I'll take a look to see if you do, then I'll give you a lawyer. I'll have you go with Deputy Miranda now. I'll have you sign a receipt. Victoria will have you take a seat. Do not leave until you sign our bond conditions. Please.
Go ahead and sign for your reset. All right, Judge, next is page 8. Paul?
So
Come on
do you
up.
mind filing those conditions, please? No contact, no weapons, no going within 1,000 feet. Good morning, Ms. Hall.
Good morning.
Ma'am, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Oh, you're also charged with evading arrest in a motor vehicle. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
on March 19th, 2025, an officer observed a vehicle on Northwest Freeway in Harris County, Texas. The defendant was stopped at a red light when the officer was stopped at a red light when the officer's traffic signal changed to green. The officer began to go through the intersection and observed a vehicle at a high rate of speed disregard a solid red light. A traffic stop was initiated. The defendant refused to stop and continued to accelerate from units to actively evade and lose units. The defendant ran a red light and made a left turn, then traveled the wrong way through a U-turn, then continued down the street at a high rate of speed. The officers continued to pursue the defendant with emergency equipment activated at speeds over 100 miles per hour. The defendant continued to accelerate through multiple red lights, turned her headlights off, and drove in circles under the highway and drove the wrong way on the service road while attempting to evade from the officers. The pursuit came to an end when the defendant turned onto a dead-end road. The defendant tried to go around the officer's vehicle and struck the front end of the patrol vehicle. The defendant evaded for approximately 5 to 4 miles. A loaded handgun was found in the glove box of her vehicle.
Okay, this case is absolutely wild. Let's break down what allegedly happened here. Miss Hall ran a red light at high speed, refused to stop when police initiated a traffic stop, and then led officers on a dangerous pursuit reaching speeds over 100 miles per hour. She allegedly ran multiple red lights, turned off her headlights to try to hide, drove in circles under the highway, went the wrong way on the service road, and only stopped when she hit a dead end. And even then, she tried to go around a patrol car and ended up striking it. The chase covered approximately 4 to 5 miles. And here's the kicker. A loaded handgun was found in her glove box. She's facing charges for both evading arrest in a motor vehicle and unlawful carrying of a weapon. This kind of reckless behavior doesn't just endanger the driver. It puts every innocent person on those roads at risk. The fact that she had a loaded weapon makes this even more serious. What was she running from? What was she thinking? Sometimes there are no good answers.
Ms. Hall, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run her license, see if she has a license, please?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive maniacally again. If I find that you drive like this, I'm going to put you in jail the first thing, and then I will take your ability to drive away from you permanently while this case is open. Do you understand?
Yes, ma'am.
I am ordering you not to be in possession of any weapons.
Her driver's license is eligible with her.
Okay. Do you have the ability to hire a lawyer, ma'am?
I have a court appointed already. I met with her Monday when I came to court.
That may be in your felony case, but just because you have one in a felony case doesn't mean that you have one here.
Okay,
So-
may I apply for one?
Okay, I'll give you, Deputy Miranda, I'll give you an application. I'm going to sign a receipt with Victoria Webb. Take a seat in the jury box while we generate your bond conditions. Do not leave until you sign them,
Yes, sir.
please. You're Mr. Walker. Sir, Patrick Walker.
Yes, sir.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you can afford one. One will be appointed to you, sir.
All right. On Wednesday, March 19th, 2025, officers were dispatched to a call for service at 10219 Rolston Lane in Harris County, Texas, regarding disturbance. Upon the arrival, the officer spoke to the complainant. The complainant and the defendant had been roommates since January of this year, and the complainant stated that her boyfriend, the defendant's brother, were arguing about his friend being in their house as they were in the bedroom. All of a sudden, the defendant walked into her room and started talking about rent money. The complainant stated that the defendant started getting in her face, but she was backed away because she was afraid that the defendant would hit her. The defendant ended up grabbing the right side of her jeans and pulling her off the bed and dropped her to the ground, causing pain on her back. The complainant stated the defendant threatened her, stating, "I will break your jaw and make you call 911. The defendant stated her boyfriend and her friend separated to prevent a further altercation and that she wanted to press charges.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of weapons. A protective order has been issued in this case. You need to get to know it. If you do something to violate this protective order, the state can and probably will file additional charges against you. It's one of the worst cases as you can pick up a violation of protective order. Do you understand?
Yes, sir.
I will protect my county at all costs. I don't care who you are. I don't care what you are. I will put you in jail and make your bond sky high. You become a problem and you endanger my community. Do you understand?
Yes, sir.
Do you have the ability to hire lawyers, sir?
Yes, sir.
Okay, we are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign and reset. I'll then have you take a seat in the jury box. We'll get your bond conditions, we'll have you sign it, and then you'll be free to go. Please.
It's the last one.
Okay. Ready? So can you file no contact?
Yes, sir.
Ms. Zambrano,
Señor Zambrano,
that you were facing up to 6 months in jail and or, I'm sorry, up to a year in jail and or a $4,000 fine.
Entonces,
We're going to do
vamos a hacer las
on silent.
Lo permanece
Safe panel
silencio,
will
todo
be
lo
used
que
against
digas
you.
lo pueden usar
You have the
contra
right to have an
usted.
attorney
Tiene derecho a
present if you
tener
cannot
un
afford
abogado
one.
presente, si no puede comprar uno, se le asignaría uno.
Quiet for the interpreter.
On March
Ese,
19th,
el 19 de marzo de
2025,
2025,
an officer was
un oficial
dispatched to a nail salon
un
in Harris
salón
County,
de
Texas.
uñas en el condado de Harris,
The
Texas.
officer
El
spoke to the
oficial habló
complainant,
con el gigante,
who stated
que
that she
dijo
had
de
just
que ella
finished
había acabado
getting her nails done at the
hacer
nail
sus
salon
uñas
and accidentally left her phone in
dejó su
seat 3.
teléfono en la silla número 3.
The complainant
El
returned to
gigante
the nail
regresó
salon
allí
and asked if anyone would
y
help find
preguntó
her
si
phone.
le ayudarían a buscar su teléfono.
No one helped,
Nadie le
so
ayudó,
the
entonces
complainant
la
called the
gigante
police.
le llamó a la policía.
The officer
El
reviewed
oficial
video
revisó
footage.
el video.
The complainant's
El
phone
gigante, el
in a silver
teléfono,
phone case
en un
was
caso
laying on the
estaba
handrest of
allí
seat
en
3.
la cinta del número 3.
The video
El
showed the
video
defendant
demostró que la
placed
demandada
2 binders
puso dos
on top of the
cosas
complainant's
en medio
phone
del teléfono de la
and
quejante
moved
y
both
movió los
binders
dos
along with the phone.
libros junto con el teléfono.
The defendant later handed the
Le
phone to
dio
her
el
12-year-old
teléfono
daughter.
a la niña de 12 años.
The defendant
La
denied
demandada
having the phone.
negó haber tenido el teléfono.
The defendant's
La
daughter stated
demandada,
that
la
the
hija,
phone was
dijo que el teléfono estaba
located in the
localizado
trunk of the defendant's
el
vehicle
vehículo
and
en la
returned it to
cajuela
the
y se
complainant.
lo regresó a la
The
quejante.
value of the
El
phone
valor del
was
teléfono era de
$1,200.
$1,200.
Now, this case is something else entirely. A woman allegedly steals a phone worth only $100 from a nail salon, but the way she did it is what makes this so bizarre. According to the police report, video footage shows her placing binders on top of the complainant's phone, then sliding both the binders and the phone away. She then allegedly handed the phone to her 12-year-old LD daughter. When confronted, the defendant denied having the phone. But here's where it gets even more complicated. It was the daughter who ultimately admitted the phone was in the trunk of their car and returned it. Think about that. This mother allegedly involved her own child in concealing stolen property. The judge is about to issue some serious warnings here, including a potential immigration consequence that could affect this entire family. A $100 phone theft could potentially lead to family separation and deportation. Is any of this worth it? The answer is obviously no. Let's see how the judge handles this unusual situation.
Daughter today.
No, Judge.
Zambrano, I'm going
Señora
to
Zambrano,
sufficient
voy a
probable cause to go
averiguar que
forward
es
with the
suficiente
case.
razón culpatoria
I'm
para
now
seguir con
ordering you
las-
as a condition of
Ahorita
your
tengo
bond
como
not to have
condición
any
de su
contact with the complaining witness in this case, not to go back to this location. And I tell you now, I usually order no contact with any other parties to this case, which would include your 12-year-old daughter.
hija de 12 años.
I'm also ordering you not to be in possession of weapons as well.
Para armas de juego igualmente.
No place called.
En lugar de uno se nombraba
Sorry, Judge. It's not stated in the office report, but I'm looking it up right now.
Campbell.
Nails for you.
nails for you.
You're not to go back to nails. You are not to go back to nails for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck like Chuck in custody until this case is over with.
Que se acaba el
And then they
caso.
ship you off to immigration. Do you understand?
Él lo entiende.
If I find that you pick up any new cases, you violate any of these conditions, I will revoke your bond and
Lo
put
voy
you
a
in jail.
encarcelarla.
Do you have the ability to hire a lawyer, ma'am?
Por su propio abogado, señora.
Sí. Yes.
You're going to reset to
Le vamos a
give
dar
you time to
una
hire a
fecha para
lawyer.
ocupar un
So
abogado.
have you signed a reset with Victoria? And after that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Do not pick up any new cases. Do not endanger my community. Otherwise, it will not go well for
Si
you.
no le va a ir muy bien.
Please.
He went and took a drug test, came back negative.
Wonderful.
So we would ask the court if the court would be open to amending the deferred conditions to include obtain a valid driver's license and obtain a GED.
Come on, Mr. Spears. Good job testing negative. That's great. Wonderful. I'm happy to acquiesce. That's great. Really. So look, I'm not asking much, man. All we want you to do is things the right way. And when you do, good things happen. Just get your license, get your insurance, and then your high school diploma. That's it. And I'll make it. Does he have anything else to do on the probation?
I don't think.
I'll make you a deal. I'll make you a deal. The minute you get your high school diploma and you got that gun class done, I'll cut you loose. You're done. You're off paper. Literally done with everything. Get the high school diploma, do that gun class, you're off. I'll take you off early. The minute you got all that stuff done. Yeah?
Yes, sir.
Good job. Just do things the right way.
When he gets the driver's license, you're called specific case, and then
See that? I mean, you're holding everything in your own hand. You're holding the dismissals and everything. The quicker you do it, the quicker you're out of here.
And here is where we see the other side of the justice system, the side that believes in redemption and second chances. Mr. Spears came in, tested negative on his drug test, and the judge's entire demeanor shifted. Instead of punishment, we're seeing encouragement. Judge Fleer offered him a deal. Get your GED, get your driver's license, complete that gun safety class, and you're done, off probation early. That's powerful. The judge literally said, "You're holding everything in your own hand." This is what accountability looks like, when someone actually steps up and does the work. It's not about being soft on crime. It's about recognizing that people can change when given the opportunity and when they put in the effort. This is tough love in action. Set the expectations high, but reward progress. What do you think? Should more judges offer redemption deals like this, or does it set a precedent that's too lenient? Drop your thoughts in the comments.
All right?
Sir.
Okay.
All right, thank
Done.
you.
So, I don't know, you want to reset it like 30 days or so? You tell me.
There's enough time.
It's gonna, I don't know how long it'll take, you
A
know?
little bit longer. Can we make it a little bit longer, but if he gets it before, then all to
But,
best.
I mean, you're obviously too old to get back into high school, so you're just gonna have to do the GED, equivalency. Just test it, see what you can do, and if you can pass it and they give it to you, money,
Would 60 days be okay with the court?
Sure.
Okay. All right, thank you, Judge. All right, thanks, Rich.
All right, good job, Mr. Spears.
Can you hear me, Judge?
I got you.
Yep. Hey, I was appearing for Mr.
yes.
Let me see here. The gentleman we sent to go get the evaluation. Mr. Adrian Flores. We sent him for the TRAS. Can you hear me, Judge?
Yeah.
And then I think during the TRAS, Judge, yesterday, the day before, he started hearing voices. There was some problem and couldn't complete the TRAS.
What was the last name again?
Flores. I've got the number. Well,
Oh,
think it's
he's not on docket today though, Harold, huh?
no, he's off docket. Victoria wanted me to Zoom with you and just talk about it.
I have to move it closer because you're going to do the TRAS.
Do you have a cause number?
I have a SPIN number,
I'll take it.
03
Uh-huh.
01
Uh-huh.
6971.
And I think I think the letter styled it as he was refusing, but I think he was having a problem. I mean, I wasn't there, but just the way she described it, that's kind of what.
It sounds like he was in a psychosis, like he was having hallucinations and preoccupied, just unable to engage.
Have they not evaluated him for any kind of medication?
We can't give him medication. His competency evaluation came back and he was competent, so we sent him to do the TRAS.
So let's recomp him then, you know? I guess we should have him reevaluated, Harold,
Okay.
you know? I don't know what else we can do. We can ask for a different, you know, someone different to evaluate.
Sure. There's just a problem.
Are you okay with that?
Oh, that's fine. That's fine. Because I think,
So
I
let's
mean, maybe,
let's put him on for tomorrow. That way we can get the order done and then I can try to expedite it. So we get it done as quick as possible.
okay. You mean for Monday, maybe? It's Friday, right?
Say
No, wait,
again?
today's Thursday. Today's Thursday. I'm sorry.
Or can you be here tomorrow? Or you want to do Monday?
Tomorrow morning, I'm going to be again here in Fort Bend County, and I've got 5 cases here in Fort Bend County in the
Okay.
morning.
You want to do Monday?
I could zoom in a little later, but I could definitely. Monday's kind of busy. If I could zoom in, Judge, that'd be fine.
Yes, of course.
tomorrow.
Well, that's why we have it, Harold.
Yeah,
Just, you know,
sure.
make it easy. Of course you can.
That'd be great.
You want to do it tomorrow or when?
Sure, that'd be. We can do it tomorrow, but I think he's not in the holdover today.
No, they're on docket Monday. If he files the orders on Friday,
You know, if you do the orders today, file it tomorrow, I can sign it tomorrow and we can try to expedite it. But the main thing is that we need the orders filed. I mean, and we don't need him, theoretically, we don't need him here for you to file the order. You can just file it. And
All
then
right.
sign it and we can just set the process going. We really don't even need him here to do it, you know? I just need you to file the order and then I can
Sure thing.
sign it and we'll reach out to whoever to expedite it.
All right, I'll do that.
So you want to leave it on for Monday and just you file the order tomorrow?
Sure, we can do that.
Okay, done. Just do that.
Yes, sir.
then.
All
Okay.
right. Thank you, Judge. My big
Let
excuse.
me know.
You have a good day.
Thanks, you too. Take
Thank
care.
you, yes, sir.
Okay, you ready?
yeah. You want to wait for a dresser.
Go. Hi, Ray. Listen, man. Are you and your girl?
Yes. The other day you and I spoke and you said you wanted to know about it and said, let's wait to see what pre-trial says before.
I haven't even seen it.
No, I haven't seen anything back either. But we had agreed not to put it on for Friday. I failed to tell Victoria not to put it on for Friday, so it's on for tomorrow.
I just wanted to make sure that's what you wanted to do.
What are we doing? I don't even remember.
So this is the one, it's a BVR with whatever.
When did we put it on?
So it's for April 30th was the next reset date. We wanted to see if there was anybody that could tell us what the lab reports.
I forgot to even look to see if they replied to me. Let me look.
I haven't seen, unless he didn't reply to all, I haven't seen anything, but it doesn't mean they didn't reply to all.
You know, replied.
Yeah, so I think it would kind of be fruitless to even have anything until we know a little bit more as far as are those medications.
Find out who the supervisor of the head.
I think we would just need to subpoena somebody from Aver Health to come testify about it because it's, from what I've been told, it gets sent out to Aver Health and somebody there would be somebody who could tell us whether it was a false positive.
Who's in charge of pretrial services again? Who's like the head person?
Her name is Natalie. I can't pronounce her last name.
I know who you're talking about. Okay, let me email her.
Okay, so can we take it off for tomorrow until we get a response on this?
Let's set it, because I don't want to forget about it. So how about we set it for a week and I'll waive the appearance?
That's fine.
And then
Did you want to put it on for?
Thursday, next Thursday.
Thursday, the 3rd, April 3rd?
You okay with that?
Well, because it's a BVR the Friday.
Whatever you want. I don't care.
Thursday's fine. Thursday would be better for me because Friday I don't have anything, so.
No, well, let's set it for Friday.
Oh, come on. That's messed up.
All right,
Messed
right.
up.
Happy Friday.
Okay, Thursday.
John, or Harold, wait.
Oh, it's the BVR.
Can you hear me?
You said waived, right, Judge?
Oh, okay.
Yeah, I can hear you.
Hey, Judge. So, Victoria was telling me I have a guy named Ortega that I'm attached to, but I've looked. I don't believe I have a client named Ortega. do you know what case number this is, or?
You mean for the one that we were talking about earlier?
No, that was Mr. Flores. But
Okay,
this
who are you
is,
talking about?
someone named Ortega.
Ortega. Are you telling me that you have an Ortega on the docket?
I don't, but Victoria was telling me that I'm attached.
The attorney is James Landry. They're spelled different.
Oh,
Yes.
yeah.
That's a-
Yeah,
That's a
different.
completely different person, man.
My bad.
So Victoria says she's sorry. Don't worry,
No
we'll
problem.
put her on probation.
No,
Yeah.
house arrest.
Yo,
House arrest, please.
really? Thanks, Harold. It's not you. It's someone
No,
else.
no problem. I just want to make sure it wasn't me, but thank you so much for calling me.
Thanks, friend.
You have a good day.
You too. John D.
Blaze is taking the.
That's on me too, I should have called it a Jason.
Judge, did you just call
Yeah,
Johnny?
hey. Okay,
Hey,
so
Judge,
John,
I'm listening, Judge.
you got Hunter back there.
No, page 39, white.
No.
White.
Why? Yeah, so basically I came in and I talked to Richard yesterday. His felony is 4-8, and Rich was going to evaluate it. And, I can set up for trial, and he thinks that, he's going to talk to felony and see if he can, do something else with it. But I know it's on your docket for a while. We've been carrying.
What do you think?
So, I mean,
Kind of sucks that it's a mischief, though.
right.
He's been in custody forever, though. I mean,
Right, and he's,
Restitutions.
and that's the thing, Judge, I think he's stuck in there on the felony, it's a state jail, I think he was just.
He's stuck in there on our case, too.
In our case.
He didn't make $100 bond.
Yeah, so. And I think, Your Honor, I was trying to get a hold of the complainant, I know it's old.
What's the alleged mischief?
It is, Your Honor,
It's a hotel room, Judge.
yeah, there was a hotel room,
He also a vehicle.
he also had a vehicle, so he punctured a tire on the complainant's vehicle, 230 bucks, and then there was a.
You want to set it for 4-9? And then that's the
I'm
last
fine with that,
reset?
Judge.
Yeah. We have an offer on there, but I told John that I can evaluate, see if felony.
Okay, do that. Let's have a decision, hopefully. By.
I will have to do
All right, we'll set it for 4-9, day after.
You got it, Judge. That's perfect. I think that's the only one in question. Everything else.
No, you got Hunter.
Yeah, Hunter, I think we're waiting for 911, Judge, and I think the state was still evaluating
That's an
that.
early case.
Yeah, it's an early case. I didn't think there was an issue on that one.
May 6th through 8th.
May 6th through the 8th. Wait, May?
Just pick
Only
just
93 days old. So it's like.
We're already in May?
I did some.
What
June.
the hell? June?
Yeah, for arraignments 2 months out.
Holy moly.
So sure.
So what do you say, John?
yeah, whatever, Victoria. Just pick a date. I'm good with it.
7, May 7th.
Perfect.
Okay.
Okay, so wait, it's good to go back.
Is that it? We done?
That's it, Judge. That's it.
And that wraps up another intense session in Judge Fleer's Harris County courtroom. Today, we witness a powerful range of cases that showcase just how complex, emotional, and high stakes the justice system can be. We saw a father facing assault charges after allegedly punching his partner in a NICU ward, right next to their newborn baby. A case that ended with protective orders and strict bond conditions. We witnessed a chilling harassment case where a man allegedly made over 109 calls in a single day after being told to leave someone alone, then tried to break in through a bathroom window. There was a wild high-speed chase topping 100 miles per hour with a loaded weapon involved, and a bizarre nail salon theft that could have immigration consequences for a mother and her 12-year-old daughter. But perhaps the most powerful moment came with Mr. Spears, a rare glimpse of redemption in the courtroom. The judge offered him a deal. Test clean, get your GED, get your license, and you're off probation early. It's a reminder that the justice system isn't just about punishment. It's also about accountability and second chances for those who earn them.